Welcome to Real Estate Resource. Thanks for stopping by. Don't forget to like, subscribe, and hit that notification bell so you'll know when new videos are available. I really hope you enjoy this one. All right, so my intention is we're going to get done today, so I might move a little fast. If you do have any questions, I did set it so you guys can unmute yourself, so either type them in the chat or raise your hand. I think maybe that'll slow down, that'll speed up our process so we can get through this today and be done. And then remember, next week I am going to be talking about the buyer representation and broker compensation agreement so that you guys can get started working that into your business now before we get to any potential changes to our practice in July. So without further ado, let me share my screen. All right. So what you guys should be looking at right now is paragraph 11 of the purchase agreement. Now, remember, we already went through paragraph 3 weeks ago, which is where, we started that weeks ago. That is where all the negotiation is done. These paragraphs now that we're finishing with, these are the description paragraphs. These are the paragraphs that give more information to each of those referenced paragraphs in paragraph 3, so that if you have a question about the disclosures or about the deposits and things like that, these are the paragraphs you go to get that clarification. So instead of reading this entire paragraph, because 11 is huge, what I did want to share with you guys here in paragraph 11 is these are statutory disclosures. These are disclosures that the state of California requires to be part of a transaction. Doesn't matter if it's a for sale by owner. Doesn't matter if there's a broker involved or not. It doesn't matter. These disclosures have to be made. And the state of California does not allow a buyer to waive their right to receive these disclosures. So even if a buyer were to say, I do not want any disclosures, and the seller does not provide the statutory disclosures, the seller could still be liable for non-disclosure of those issues. So you got to know that. You have to know that these disclosures that we're going to talk about in this paragraph specifically have to be provided no matter what. Okay? So it's here, it says the seller within the time verified in the time specified in paragraph 3 and 1, that's 7 days, right? We know that the seller by default has 7 days to provide all of the seller's documents to the buyer. That includes the disclosures and any other reports and things they may have. So the disclosures that are in here, the statutory disclosures, are the real estate transfer disclosure, the TDS, the NHD statement. Now, NHD statement and the NHD report that we normally use are two different things. But that NHD report replaces the NHD statement. The NHD statement is basically a 1 or 2 page form that the seller has to answer the questions. Do you know if you're in a high fire zone? Do you know if you are in an earthquake zone or flood zone? Sellers don't know the answers to those questions. That's why we use the third-party companies that do those NHD reports. That is what the NHD statement is the one that's filled out by the sellers, but our NHD report replaces that. Okay, so you don't have to have that form filled out by your seller, because obviously they're not going to do it. But that's one of them. The next one is they have to acknowledge if they know of any release of illegal controlled substances, any notices of special taxes or assessments. Okay, the Mello-Roos, if there's a Mello-Roos in their area. If there's the knowledge of the industrial use and military ordinances, all that stuff is actually covered in the SPQ, right? So again, when the way they lay it out is there's specific questions in the SPQ that cover those disclosures that the seller is required to make. So the SPQ is required. There, it says there CAR form SPQ or ESD. The ESD is an exempt seller's disclosure. And we're going to talk about who gets to use exempt sellers disclosures in a moment, okay? The other thing that's in there is, obviously it says here, if the property is in a high or very high fire hazard severity area, the information, notices, documentation, and agreements required by Civil Code 1102.6F and 1102.19 of the Civil Code, CAR form FHDS, that's the fire hardening, right, disclosure, and that's only required if it's in a high or very high fire, okay? So this is talking about the TDS and all these forms that have to be provided, right? What I always like to remind you guys is, remember now the TDS right here, I'll be with you in just a minute, Jesus. The TDS here, right, it's talking about it being statutory, and it mentions the AVID. So your AVID is actually part of the transfer disclosure statement. So if you are failing to provide your AVID within that 7-day period to make it part of the transfer disclosure, then you are delivering incomplete disclosure to the buyer, okay? It doesn't usually come up as an issue, but I just want you guys to understand the AVID is technically part of those disclosures that need to be provided. Make sure you're providing them. Okay, so Jesus, go ahead and unmute.
Yes, my question is this. The NHD is a report provided more thorough, more knowledgeable than what the seller would give us, right? Because they don't know anything. Now, what if the NHD report misses something is wrong? Can we sue them?
Yeah, they're bonded. They have insurance. If they mess up, then they're responsible for it.
Okay, because in my case, we are not in a fire zone. I mean, we're in a fire zone, but we're not in a mudslide zone or a flood zone. And then you saw what happened. So I'm wondering if I have a case.
Not in, I mean, if you're not in a flood zone and that happened, I'm probably not against them because they disclose the right information. But yes, if NHD companies do not, they are bonded, so they have insurance, they have stuff to protect them because they're relying on their information. So yeah, if they were to leave out something that was,
Thank you.
It caused you damages, yeah, probably they could be held responsible. Okay, moving on. Okay, so just know that you've got to give all of those disclosures, right? So it says here, seller shall within the time specified in paragraph 3.1 provide supplemental disclosures as follows. Unless exempt from the obligation to provide a TDS, complete a seller property questionnaire by answering all questions and signing and delivering a copy to buyer. If exempt from the obligation to provide a TDS, complete an exempt seller's disclosure by answering all the questions and signing and delivering to the buyer. So in the case where a seller is exempt from the TDS, they don't have to provide an SPQ. They only have to provide the ESD, the exempt seller's disclosure. So those sellers that are exempt from a TDS are probates, REOs, and trust sales where the successor trustee is the seller, okay? If it's the original trustee, they're a regular seller. They have to provide everything. And the difference between a trust and the probates and the REOs is if the trustee, the successor trustee, actually has that property that they're selling as their principal residence, they're required to make the full-on disclosures, TDS and SPQ. Okay, so those are the only people that can use an exempt seller's disclosure. Not an investor that purchased it and is flipping it. They can't. Not somebody that bought it at auction and is flipping it. It doesn't matter if they've never lived in the property. If they are not an REO, a trust sale with a successor trustee, or a probate, they have to provide a TDS or an SPQ and an SPQ, okay? Period. In the event the seller prior to close of escrow. So what this is saying is if there's any changes, right? I'm not going to read it. I'm just going to, if there is any change, let's, for example, I've already given you the TDS. It's well past the 7 days. I've given you all my disclosures. You may have even removed your contingencies as buyer. There's a flood in the house. Now I have to update my disclosure, right? I have to disclose to you that there was a flood because there was damages done. I have to do a new SPQ. I have to do a TDS. I have to give you the new documents in writing. Okay? Now, if I find out something's wrong with the property because you, buyer, did a home inspection, I don't need to amend my disclosures. I do, though, for any subsequent buyers, right? Like if you cancel on me after you tell me that, then yeah, then I have to. Okay, I have to disclose it. But if you find out about it, I don't have to change my disclosures. If I find out about it, I have to change my disclosures to let you know, okay? The lead-based paint disclosure is also one of these statutory disclosures, has to be provided, okay? The home fire hardening disclosure and advisory, this is just Again, where there's a transaction with the TDS, we've already talked about that disclosure, the dispensable space disclosure, same thing, high or very high fire, okay? Here's what I talked about earlier. The waiver is prohibited. Waiver of statutory lead and other disclosures in paragraphs 11A1, 11B, 11C, and 11D are prohibited by law. You cannot waive them, okay? Return of signed copies. Buyer shall within the time specified in paragraph 3L4 or 5 days after delivery of any disclosure specified in paragraphs 11A, B, C, or D, and defensible space addendum in paragraph 11D, whichever is later, return signed copies of the disclosures and, if applicable, addendum to seller. Okay? So you got 5 days or until your contingency period is up. Termination rights. This is important to understand. Statutory and other disclosures. If any disclosure specified in paragraphs 11A, B, C, or D, or subsequent or amended disclosure to those just specified is delivered to buyer after the offer is signed, buyer shall have the right to terminate this agreement within 3 days after delivery in person, or 5 days after delivery by deposit in the mail or by an electronic record or email satisfying the UETA, by giving written notice of rescission to seller or seller authorized agent. If buyer does not rescind within this time period, buyer has deemed to have approved the disclosure and shall not have the right to cancel. So buyer has a 5-day right of rescission from the time they receive those disclosures, regardless if they have their contingencies removed or don't have them at all. So when we go back to that statement where we say, hey, later on, after we've done the disclosures, we have to amend them because something new happened, they also get that new 5-day right of rescission, which means they have the right, just based on getting the disclosures, to be able to cancel. Okay? There's a question here in the chat. Let me get over to that. Let's see. I have a property coming up where someone died outside the house on the sidewalk by stab wounds 5 years ago. Do they need to disclose it? No, legally they don't need to disclose it. But if it's something that neighbors talk about, it's probably something you probably want to disclose, because if you don't, the neighbors are going to tell them after. But no, you don't have to disclose it. If property was built after 1978, do you need no, you don't need after that. After 1978, you don't need the lead-based paint. Okay, so that's termination rights, right? That's the thing, is you have to understand, if I deliver these, the sooner that I deliver the disclosures to the buyer, the less time I give them to cancel. And anytime I amend these disclosures, I am now giving them that right to cancel, okay, to rescind their offer, just based on those disclosures. Withholding taxes, that's just an explanation of that the seller is going to provide to the buyer the seller's affidavit saying that, yes, we pay our taxes. That's it. Megan Law database disclosure, just saying go to this website to check Megan's Law. If I were you, I probably wouldn't check that as an agent, because you've got to disclose what you know from Megan's Law disclosure. So let your buyers go on there, but you don't. The liquid gas and hazardous liquid transmission lines. Again, there's the website to see if there is any transmission lines that run under the property. This is referring back to the natural and environmental hazards, which is covered by the NHD report. The condominium and plan development disclosure. Okay, seller shall within time specified disclose to buyer whether the property is a condominium as they're located in a planned development. That's on the SPQ. And we already know, we're going to know that ahead of time, but yes, that disclosure is made in the SPQ, and part of those disclosures are, part of that, their requirement is to get those documents from the HOA, okay? Solar power systems, again, there's a form called the solar, which is perfect for it. That's part of the delivery that has to be that disclosure. The solar disclosure has to be given to the buyer in the same period of time, those 7 days. And then the buyer has the same right of investigation to be able to see, can I take over the lien or lease or whatever exists on it? And it's a contingency whether they want to or not. So they can cancel based on that, okay? Sellers shall disclose known material facts and defects affecting the property, including but not limited to known insurance claims within the past 5 years, or provide buyer with permission to contact insurer to get such information, CAR Form ARC, and make any and all other disclosures required by law. Okay? So you have to disclose that, and especially now, if there has been claims against the property, you have to disclose that, because and for us as buyer's agents, we got to get on it from day one, making sure that we can get that buyer insured on that property. Solar rights apply regardless of inspection. Yes, they're separate contingency. The leased or liened items, things like that, that's a separate contingency than just investigations. Okay. Buyer's investigation of property and matters affecting property. It's just saying in the time specified, whichever you negotiated by. Again, the default of the contract is 17 days, but people negotiate all that. This is a list of all of the, well, not all. This is a list of possible inspections. It's just basically saying, buyer, you have the right to do whatever inspection you want, whatever you want to pay for. Okay? You could pay for anything and do the inspection. The thing is, you just have to, when you're doing that, you have to make sure that you are not damaging the property. And anytime you damage the property, you're going to be responsible for fixing it. And the other thing you can't do is you cannot cause a government inspection of the property if there's not a government inspection required. So, for example, if I'm buying a house and I'm a buyer, right, and I go in and I start to do my investigations, and part of my due diligence and investigations and buyer's agents, you guys should be making your buyers do this, is double check the permits on the property so there's no surprises. Go to the city, give them the address and say, I need to see all of the permits pertaining to this address. And that's it. That's all they're going to ask for. Now, you could go with them, but you want the buyer to ask for it, not you, the buyer. You could take them, or you can send them on their own if you trust them. But the only question is, can I see all the permits associated with this address? Not for a specific permit, like, hey, I need to see the permit for the master bedroom that was added. Or I need to see the permit for the ADU conversion in the garage. Not specifics, just all of the permits for that address. And if I go there and say, hey, by the way, city of whatever, I think that they did their add-ons without permits. I think you guys should check it out. If it causes the city to go do an inspection and causes, costs or anything for the seller, the buyer could be held responsible if they're the ones that caused that inspection when there is no inspection required for the city. Okay, so you got to be careful with your buyers, and that's part of the thing is asking for specific permits, because if they say, I need a permit for the master bedroom, and there isn't one, the city's going to be like, hey, this house has a master bedroom without a permit. Let's go check it out, right? It could happen. So they have to be really careful of that, and that's why I say to you, it's better if you go with them, but let them ask the question. And whatever you do not go to the city for them as buyer's agent. As buyer's agent, you don't go and ask to see the permits. You don't go to check on any of that stuff, on what they may or may not, what they may or may not be able to build or add on or whatever. You don't do that for them, because if you get misinformation from the city and you're the one that goes and gives that information to the buyer, you're now responsible if that information is incorrect, meaning they can't add on or the permits weren't right. You are held responsible now. So put that on your buyer. Take your buyer there. Let your buyer talk directly to the city so the liability falls back on the city. Okay. And as sellers, listing agents, don't go pull permits. You don't need to. If the seller says, I don't know if it's permitted, leave it at that. Make that your disclosure. Seller doesn't know if this item is permitted or isn't permitted. They purchased the home this way. Buyer to do their own due diligence and, and satisfy themselves to the, to the condition of the property. That's it. Let the buyer go do it. Unless your seller knows specifically, hey, that thing is not permitted because I built it, then you need to disclose it as non-permitted. Okay? So let them do that. This section right here, I think, is also very important, the buyer indemnity and seller protection for entry upon the property. So the buyer basically is saying by signing this that I am whoever works for me and goes on your property, you're not responsible for anything happening to them. Okay? That's basically what they're saying. They're saying that I'm taking that responsibility. So when we hire people like professional home inspectors, right, because there is no licensed home inspector, professional home inspectors and appraisers who are licensed, and anybody else, you might, or maybe a termite inspector, or a roof inspector, whatever, a roofing company. They're all licensed professional people, which means they should have some kind of liability, workman's comp, that kind of insurance. If I were you as buyer's agent, I would make sure that anybody that my buyer's choosing to hire, whether it's somebody I referred them to or they found on their own, that you get a copy of their workman's comp and liability insurance to make sure that there's not going to be any problems for your buyer, right? Because if I hire somebody to go do an inspection, whether that be a roof or a termite or a home inspector, and they don't have any insurance, they don't have workman's comp or they don't have liability insurance, and they injure themselves on the seller's property, their only recourse at that time would be to go after the seller's homeowner's insurance. Okay? Now, because the buyer has to indemnify the seller from any liability and protect them, the seller could now go back and say, okay, buyer, you hired that person. They got hurt. They sued me. You're going to now compensate me for the damages I incurred. So when you hire people, if I were you, if you guys are using the same services, I know I tell you that you should offer them 3 choices and all that stuff, but if you're using the same vendors over and over again, you should have on file a copy of their current workers' comp and liability insurance, so that if anything like that ever were to happen, you would know, hey, they're not going to go sue the seller because they have their own insurance, and you'll be protected. It's a good thing to sell when you're going on listing appointments. This is a good thing to talk to the seller about, is saying, I'm going to make sure that before the buyer brings anybody on the property, that they send us a copy of their workman's comp and liability insurance for their vendors. And if they don't have that, I'm not going to allow them to come on the property. Right? So how many times have you guys as agents had a buyer say to you, hey, I'm not going to hire a professional home inspection company because my cousin is a contractor and he's going to walk through and tell me how much stuff is going to cost to fix and, you know, what the condition is and what repairs I should ask for. Happens all the time. Those people are not licensed. They're not bonded. They have no workman's comp insurance. They have no liability insurance. If that cousin goes up on the roof and falls off and breaks his legs, he's going to sue the seller. And in turn, the seller's going to sue the buyer because they brought somebody unlicensed. And then guess who else is going to get sued? Me, the agent, because I let them do it. Right? So I'm going to sit down with my sellers and say, hey, by the way, did you know that anybody that the buyer hires is required to have their own insurance, and the buyer is required to indemnify you from any liability? So what we're going to do is I'm going to counter all my buyers, and I'm going to say, by the way, I need to see a copy of workman's comp and liability for any vendors. Maybe that's a way to separate myself. I know that none of us are going to do that because it's in the contract, and I know that you guys aren't going to take that extra step, but think about what you could do to separate yourself from other listing agents, to show them why they're hiring you, because, you know, ultimately we think our job is to sell their house. Their house is going to sell. You guys could, you know, be mutes and sell their house. It's not like your sales skills are getting their house sold. Your sales skills are getting you hired. Your job is to protect them through the transaction, make sure they're getting the best deal, protecting it so that the money that they do get from the sale of the house, they get to keep all of it. And this is one of the things that you could do to differentiate yourself. Instead of talking about how pretty my pictures are, which I know you need to do, think about this. This is the nuts and bolts of things that I do different than other agents. Okay? There is a mention here of a form called the NNR, which is the Notice of Non-Responsibility. And that's another form that we really don't talk to sellers about. Now, for buyers, it doesn't really matter. For sellers, it does. And if we want to explain it properly to a buyer, we could, so they understand what it means. But really what a Notice of Non-Responsibility does is it protects the seller from a third party who hires somebody to do something on their property, from that person, that vendor, to be able to file a mechanics lien against the seller. Because that's how mechanics liens, for those of you guys who don't know what mechanics liens are, you hire somebody to do work for you, you refuse to pay them, their only recourse to get paid is they filed a mechanics lien on the property, so that when you sell the property, you have to pay them off, or you have to pay them to negotiate to remove it, right? So for example, I know that there's a lot of sellers out there that don't want to do lender required repairs or have repairs done prior to the close of escrow that need to get done, and they put it back on the buyer. So now the buyer's hiring the worker to do that so that they can get their loan approved, right? So the buyer hires somebody, does the work on the property, whatever it is, fixes the floor, fixes the windows, whatever it is. And then the deal doesn't close, and the buyer doesn't pay that vendor because they're like, well, I didn't get the house, I'm not going to pay him. They're going to go file a mechanics lien against the seller because the seller benefited from their work. The notice of non-responsibility, what it does, if you go and you get it notarized, record it with the county, and post it on the front door and back door of the property, is anybody that comes on that is not hired by the seller now is protected from that person filing a mechanics lien if they don't get paid. Okay. Now you can't file these at the very beginning because it's going to look weird. It might cause a cloud on title and raise a red flag. But if you do it in accordance with the escrow opening, a title will understand why it exists. Okay. So that's what the notice of non-responsibility. It doesn't protect them from people getting hurt. It protects them from people doing work and not getting paid when they're hired by somebody other than the seller. Okay. But if the seller hires them, just because they have that notice of non-responsibility, they're not off the hook. They would still be required to pay. Okay. All right. Title investing. This is just saying, hey, you're going to get the preliminary title report within the time periods that were agreed upon in 3N1, and then who's responsible for paying for that, how you're going to hold title, all that stuff. Okay. The time periods, this is where it's going to refer to all the time periods. So if you're ever questioning what documents have to be delivered by the seller, here's all the paragraphs: 7A, 9B, 6, 10, 11A, 11B, 11C, 11D, 11H, 11K, 11L, 11M, 11N, 13A, 13C, and 28. So if you ever want to know what does the seller have to provide in that 7 days, everything in those paragraphs. Those paragraphs will tell you all the documents the seller is required to provide. Okay. The buyer is going to do all of go through the documents and the disclosures that they receive from the seller. They're going to investigate them. They're going to do their investigations by hiring a professional home inspector, going to the city, whatever other inspections they want, and they're going to do that. They're going to do that in their time periods, right? Which is what was referenced back in 3L, which is 17 days or whatever you guys negotiated. The buyer, during that time period, they can make a request for repairs. Okay. The seller has no obligation to agree to or respond to buyer's request. That's one of the things I like to stress to you guys, because I hear it a lot still, is agents come to me and go, we send a request for repairs and they're not answering us. Well, just know they have no obligation to agree to or respond to buyer's requests. Now, if you're a listing agent, please respond, right? If you know your seller doesn't want to do the repairs, respond. Okay. If you aren't going to respond to them, at least tell them over the phone, hey, we're not responding. Don't ignore them. It's crazy to me that people just don't communicate at all. Okay. But there is no requirement. So if seller does not agree or does not respond, buyer is not contractually entitled to have the repairs or other requests made and may only cancel based on contingencies of the agreement, right? So you're not canceling because they didn't do the repairs, but you just don't like the condition of it because they're not doing the repairs, but nothing requires you to do those repairs. Okay. Now, in these cancellation rights and things like that, they always say it's either remove the contingency or cancel. We know that those aren't the only two options. It's not black or white. There is gray, which means we can negotiate, right? We can negotiate extensions. We can negotiate different things. We don't have to remove it or cancel. Okay. Buyer shall, by the time specified in 3L, or deliver to seller a removal of the applicable contingencies or cancellation of this agreement, like I just said. However, if any report, disclosure, or information which seller is responsible is not delivered within the time specified in 3N1, then buyer has 5 days after delivery of any such items, or the time specified in 3L, whichever is later, to deliver seller a removal of applicable contingency or cancellation of the agreement. So what they're saying is that if you, no matter when my documents from the seller get delivered, the time periods are either going to remain the same or it's going to be 5 days after delivery. So if there's still more than 5 days to go from the time I get all the documents until my contingency is up, then my normal contingency period applies. If there's less than 5 days, then the 5 days after delivery applies. So what you guys have to think about is this. If you're telling people that they have 5 or 7 days to do their professional inspection, right, their investigations, that investigation period contingency, and you're not giving them disclosures until 7 days like the seller says, they're going to have 5 extra days. They're not going to have those 7 days. You can't ask them to remove contingencies if you don't deliver. So if you're going to shorten, guess what you need to do? All of your seller documentation needs to be ready to go on day 1, meaning if you're going to send it, you should send it with your approval, right? So as soon as you sign off that we're accepting the counteroffer, when you return that to the buyer, it should include all the disclosures if you want to shorten their time periods that much, okay? You got to know that. All the contingencies, if you don't remove them in writing, they continue, right? So even if we get one of those where they say, hey, you guys got 5 days to do your inspections. Day 5 comes and goes. Day 6 comes and goes. Day 7 comes and goes. Day 8 comes and goes. Day 9. And they haven't sent me a notice to buyer to perform to remove my contingencies. My contingency is still in effect, even if I've gone 10 or 20 days past our original agreement, okay? So you have to understand that the contingencies continue to go. The seller, the only way the seller can cancel on a buyer is if they send them a notice to perform based on the contractual obligation or a contingency period, and the buyer doesn't perform. Then the seller can send cancellation rights. And that notice to perform does not expire, which means if I send you a notice to perform today, which means you have to perform on Saturday or Monday, it would carry over to Monday, and Monday you don't do it, and I wait a week or two and then decide, you know what, we're not waiting anymore, I cancel. I would have the right to do that based on that notice to perform because you didn't perform. Now, if I sent you a notice to perform and then we agreed on an extension, and then I wanted to cancel after the extension, I'd have to send you another notice to perform because we now negated that notice to perform and we gave you an extension, okay? So the only way the seller can cancel is if you give them the notice to perform first, the buyer doesn't perform, then the seller can cancel. The seller can cancel also for their own contingencies. Obviously, if they have a contingency in place like finding a replacement property, they can cancel for that, okay? Buyer's right to cancel. Again, if the seller's not performing, they're not giving me the documentation that were required, we can send them a notice to seller to perform. If they don't perform, we could cancel. But we also know that the buyer has the right to cancel because they have the contingencies in place, okay? Notice the buyer to perform and seller to perform. The default is 2 days. You cannot change that. So just because I get a notice to perform and write 1 day or 24 hours or whatever, it doesn't change. It's 2 days by default. The only way I could change that is if I were to counter and say buyer and seller agree the time period for notice to perform is now 1 day. But you got to remember that counts for you too on the notice to perform. This is just effect of the contingency removal. It just means that you could be responsible for any costs and lose your deposit and the cancellation rights. That's what they're talking about. Demand to close escrow. Again, that's what you do on close of escrow. You can only send a demand to close escrow, not a notice to perform, and you got to give them at least 3 days. So if you're late, you're past your escrow period, you got to give them 3 days to do it. You got to give them 3 days to close. If you're prior to your close date and you just want to close on your close date, you can't send it sooner than 3 days prior to your close date. Okay, let's see, Melissa. Wait, how do we reduce notice to perform time to 1 day? You would have to write that in a counter offer. That's the only way you could do that. That's what I was saying. If you're a seller and you want to reduce the amount of time it takes for a notice to perform, you could say in the counter offer, buyer and seller agree that the time periods for notices to perform is 1 day after delivery. You could do that. I wouldn't suggest it, but you can do it, okay? Effective cancellation on deposits, all it's saying is look, if I cancel, if I'm the buyer and I cancel and I have removed my contingencies, so I'm acting in bad faith, I could lose my deposit. And as seller, if I cancel and they still have their contingencies in place, I have to release their deposit to them. The bold type here says a party may be subject to a civil penalty of up to $1,000 for refusal to sign cancellation instructions if no good faith dispute exists as to which party is entitled to the deposited funds. So what we're saying is if I'm the buyer and I am in breach, I've removed all my contingencies and I'm still canceling, and I'm not agreeing to release my deposit, if the seller were to take me to small claims court, depending on the amount, or through mediation arbitration, as buyer, I could also be responsible for this $1,000 civil penalty because I'm not performing to the terms of the contract that I agreed to. And vice versa to the seller. If I'm a seller holding onto the deposit when the buyer hasn't removed any contingencies or hasn't acted in bad faith, I could also be subject to that $1,000 civil penalty. So you got to understand that that's a conversation you have to have with your clients who are adamant about, I'm not releasing or I'm not doing, the things I'm supposed to do. Okay. The repairs, it just says that the repairs are supposed to be done by the time you do your final walkthrough, and they're supposed to be done in a workmanlike manner that complies with any applicable laws. So what does that mean? It means it has to be done professionally. It doesn't mean it has to be done by a professional, but it has to be done professionally. And if it requires a permit, you're required to do it with permits. The only way you could do it without permits is if you got agreement from the buyer that says, okay, we'll do these repairs, but we're going to do these repairs without permits. And if the buyer signs off on it, then you're okay to do that. But otherwise, has to be done that way. And if you choose not to hire a contractor, somebody who's licensed, bonded, and insured, right, to do any of the repairs, you hire a handyman or you choose to do them on your own, you then have to warranty that work that you did, right? So if you do the repairs on the plumbing and it wasn't done by a licensed plumber who has a business that gives you a receipt and says, I did this work, that warranties the work they do, the buyer would come back to you if anything went wrong with that repair you made. So my suggestion is you always tell your sellers, you hire a professional to do these repairs, because that person now takes on the liability if there's anything wrong with those repairs in the future. Okay. So that's it. Done in a workmanlike manner. If it requires permits, you got to get permits unless you have something in writing, and you're responsible for warranting the repairs that are done if you don't hire a licensed contractor to do those repairs. Final verification of condition, which is your final walkthrough, is not a contingency of the sale, but solely to confirm that the property is in the same condition it was when he wrote the offer, and that any repairs that were requested were completed, okay, and agreed to were completed. That's it. So it's not a contingency, which means I don't get to cancel if I don't like the condition of the property at the end. I could still lose my deposit if I do that after the walkthrough. There's different things that we would do. There could be some civil case that we could handle later after the close because of the condition, but you can't cancel and ensure that you're going to get your deposit back. Can liability for warranties on work be released if you disclose work is done by a handyman and buyer signs off on it? Well, I mean, it could. No, because I mean, even though they know that you're going to do it without permits or by a handyman, somebody still did the work. So you're basically now acting as the contractor. You could still be held responsible just because they say, okay, yeah, we know it's a handyman. Doesn't mean. Maybe if you put in writing like, hey, we're agreeing to these repairs and it's going to be done without permits, and buyer, holds us harmless, and we have no liability towards the seller for any future repairs based on this repair. You could do that, but even then that could be tough to defend in court, right? Let's see. Brokers, agents. Let's not talk about compensation right now just because of everything that's going, but it is saying that, hey, whatever the compensation is written is how we're going to do the work, right? Is how it's going to get paid out. Scope of duty. It's basically trying to say to the buyer and seller, hey, the brokers are just kind of here to guide you. We're not making any decisions on the prices that you pay or the people that you hire and things like that. So that's why I would say just be careful that you're not being the one who is hiring the vendors. You're not picking the home inspector. You're not hiring the home inspector. You're not picking the plumber. Let the buyer do that kind of stuff. So it takes a little bit of that liability off of you. Okay. Do you have to disclose that it's a handyman at all? I mean, I would, just to make sure that they're clear on that it was a handyman. Because you do at the final walkthrough, you have to provide them with any receipts and proof of the repairs being completed. So they're going to know that it's not a contractor anyway. I just think it's better to be transparent. I would just be like, hey, listen, all the repairs are going to be done without permits, and they're being done by someone who's not a licensed contractor, period. That's it. But they'll be done, in a workmanlike manner. That's it. But if that's the case, if you guys, I mean, look, I would prefer you guys just try to give a credit than have a handyman do the work. Let them be responsible for that. Because I wouldn't want to have to think about it later. Just either don't do the repairs or give them a credit if you can and let them handle the repairs later. This is joint escrow instructions for the escrow holder. This is where the escrow holder gets their escrow instructions from, these paragraphs that are all listed here, and I won't read all of those. But that's where the escrow instructions come from. Whatever is in those paragraphs is what's in the escrow instructions. Now, our sister company downstairs, they just use the purchase agreement as the the majority of their escrow instructions. They have a few addendum that they do, for what they need to do for escrow, but they just use the purchase agreement as their escrow instructions, which is perfectly legal to do that instead of having to copy and paste them basically into a new document that needs to be signed. But if you do use an escrow that doesn't do that, then you need to read the escrow instructions and make sure that the information matches the information in these paragraphs. You guys should be reviewing those escrow instructions, okay? We're going to move on. This talks about the selection of service providers, which we talked about, multiple listing service, attorney's fees. If there's any action, a dispute between the two, everybody's responsible for paying their own attorney fees, okay? Buyer shall have the right to assign all of buyer's interest in this agreement to buyer's own trust or to any wholly owned entity of buyer that is in existence at the time of such assignment. Otherwise, buyer shall not assign all or any part of buyer's interest in the agreement without first having obtained the separate written consent of seller to be specified by the signee. So here's what they're saying is that there is a section in the contract that says you have 17 days to assign this transaction. And that's really about assigning it to somebody else. The assignment of putting it in my corporation that I own or in my trust, I can do that whenever I want because it's still the same buyer. Okay, so that's what they're saying there, is that I can assign it to my own trust or my own entity because I own it wholly. Now, if I'm a partner, like I'm not the 100% owner of the corporation or the LLC or whatever, I have partners, that's different. But if it's my own corporation, it's my own trust, I can transfer it. They can't tell me no on the assignment, okay? Here's where all the definitions of the terms that we talked about, acceptance, what the agent means, agreement, as is, authorized agent, CAR form, what that means, close of escrow, counting days. This one is very important, and I would like to make sure that we talk about that. Counting days is done as follows, unless otherwise agreed. The first day after an event is the first full calendar date following the event and ending at 11:59 p.m. For example, if a notice to buyer to perform is delivered at 3 p.m. on the 7th calendar day of the month, or acceptance of a counteroffer is personally received at 12 noon on the 7th calendar day of the month, then the 7th day is day 0 for purposes of counting days to respond to the NBP or calculating the close of escrow date. So what they're saying is that today, we accept a contract today or send a notice to perform today, right? Today is day 0. Tomorrow is day 1, right? Saturday would be day 2. Now, for a counteroffer, that applies. You would still have to respond, right? If we accepted a counter today, day 1 is Friday, day 2 is Saturday, day 3 is Sunday. Those days all count when we're trying to figure out close of escrow date. On a notice to perform, though, if that was received today, day 1 is tomorrow, day 2 is Saturday. That's when we're supposed to perform. You can't perform on a weekend or a holiday, so it would kick over to the next business day. In this case, would be Monday. Okay. Day or days means calendar day or days. However, delivery of deposit to escrow is based on business days. The only thing in the contract based on business days. Delivered, or delivery of documents. It's just, again, they're explaining to you what delivered means. Okay. Terms and condition of offer is just here. This is the offer to purchase. Anything else that we've talked about, if it's not here, it doesn't exist. Okay. Time is of the essence. It's just we have to act within the time periods that are provided to us. Legally authorized signer, this just talks about like if it's an entity and who's the legal authorized signer, and they'll sign that and explain that in the signature section. All right, we're almost done. So liquidated damages. Okay. Liquidated damages. If buyer fails to complete this purchase because of buyer's default, seller shall retain as liquidated damages the deposit actually paid. If the property is a dwelling with no more than 4 units, one of which buyer intends to occupy, then the amount retained shall be no more than 3% of the purchase price. Any excess shall be returned to the buyer. Release of funds will require mutual signed release instructions from both buyer and seller, judicial decision, or arbitration award. At the time of any increased deposit, buyer and seller shall sign a separate liquidated damages provision incorporating the increased deposit as liquidated damages, CAR Form DID. We talked about that earlier. So what this means is Anybody who's buying a house, 1 to 4 units, and they intend to live in the property, right? If they're buying a single family and they're going to live in it, they're buying 1 or 2, 3, or 4 units and they're going to live in one of the units, then they're protected to that 3% maximum threshold that they could lose as liquidated damages. If it is an investor purchasing the property, they do not get that protection on that threshold. Okay, so what that means is that if I put a $25,000 deposit in to try to get my offer accepted, and the sales price for the house is $600,000, 3% of $600,000 is $18,000, which means $7,000 of my $25,000 deposit would get returned to me if I were a buyer, right, that was breaching the contract, yes, moved all my contingencies, and I was losing my deposit. They wouldn't keep all 25, they'd only be able to keep 18. They'd have to return that other 7,000 to me. If I'm an investor, they have no obligation to return that additional $7,000. Okay? Anybody have a question about that? You could type it or raise your hand. No? All right. So just know, liquidated damages is only for people buying their principal residence, not for investors. Okay? Mediation and arbitration of disputes. Okay, so this paragraph 31 where it says arbitration of disputes, whether or not this is initialed by both parties, mediation still applies. So if there is some kind of dispute between buyer and seller, right, whether it be the deposit or some damage to the property after the close of escrow, right, and the buyer is looking for damages from the seller, the first step is you go to mediation. Okay, now mediation isn't binding, so we could go to mediation, and the way you do it, it's got the website right there, consumermediation.org. You pay the $500. They set up mediation times. You guys meet on Zoom or in person. You mediate. The seller says their part, the buyer says their part, why, and then the mediator gives a decision and says, well, I think the buyer's correct. Seller, you owe the buyer X amount. It's not binding though. So then the next step would either be litigation or arbitration, and that would depend on if you guys initialed this paragraph. Now, arbitration and litigation, very similar. The only difference is arbitration is a lot more like mediation, where it's just in front of one person. You plead your case, the opposition pleads theirs, that arbitrator makes a decision. The only difference is it is binding. It's binding, which means you have to go through it. It's like having a judgment, right? It's the same thing. Litigation would be either in front of a judge or a jury, depending, and may take slightly longer, may cost slightly more, but it's not demonstrative. Like, it's not a huge amount, but it is going to take a little bit longer. It is going to take more money. Some people just like the idea that they have the right to go through litigation for their disputes. You can't force anybody to initial this, but if, for example, the buyer doesn't initial it and we submit our offer and the seller counters and says, yes, we want buyer to initial this paragraph 31, if they want to get their offer accepted, they're required to initial it. If they don't, then they don't get their offer accepted, because you can't have one party agree to mediation and the other party not. It has to be both or neither. What is the max amount of money to win or lose a mediation? There is no max amount. It's the same thing it's the same mediation, litigation, whatever it is you're suing for, that is the amount. It's just a process. It has to go through mediation first. And if either party refuses to go to mediation, whether you go to arbitration or you go to litigation, that party that refused mediation can no longer request their legal fees be paid for by the losing party. Okay, so if you lose the right to that request of saying, hey, since I had to bring this legal action against you because you refused to do what you were supposed to, you now have to pay my legal fees to do that, which is normal. But if I refuse mediation, I can't ask for that. Okay, so you need to know that. So whether or not you initial this paragraph or not, you got to go through mediation first. Now, there are exemptions to that. And those exemptions are Where are they? Exclusions, right here. There we are. The following matters are excluded from mediation and arbitration. Any matter that is within the jurisdiction of probate, small claims, or bankruptcy court, an unlawful detainer action, and a judicial or non-judicial foreclosure or other action or proceeding to enforce a deed of trust, mortgage, or installment sale. They're excluded. You don't have to go through mediation or arbitration. So what that means is if your dispute falls under the guidelines of small claims, right, 10,000 or less, then you don't go mediation arbitration, you go directly to small claims. Okay, so that you need to understand, right? So if, for example, your dispute is over the deposit and it's less than $10,000, you would file it in small claims court against the seller and against the escrow, because that way, if the seller refuses to show up, the judge can then order escrow to release your deposit to you and not need the seller's signature any longer, because that's legal that way. Okay, questions about mediation, arbitration? Anybody? All right, we're almost there. Look, we're going to finish. Buyer's offer, the expiration of the offer, by default, the expiration is in 3C, right? We know it's 3 days, it expires. A buyer's authorized agent, seller has no obligation to respond to an offer made. But you do as an agent. Seller doesn't, you do. You have to show proof of based on the board. Who knows if those things are going to change come July with the lawsuit settlement. But as of now, you're required to show proof that you presented the offer if you requested in writing from the buyer's agent. Entity buyers, you check that box if somebody is an entity, right? Like if it's a corporation, a trust, a probate, a power of attorney, any of those things, you have to do entity buyer. You put the authorized signatures names in there, and then they sign on behalf of the entity. Okay. The buyer's signatures are here. If we're accepting it, we would check off that we're sending a counteroffer or a seller multiple. Backup offer addendum that might be, and if the sellers are entity sellers, you would do the same thing as the buyer. Okay, send that out. Sellers sign it and send it to the buyer. Now, here's where it is. Offer is not accepted. No counteroffer is being made. This offer was not accepted by seller on this date. Seller initials it. That's all you need to do if you don't want to write counteroffers. Now, if you send a counteroffer, that's your proof of presentation. You don't have to worry about that. This is where the agents would sign, the buyer's broker, the seller's broker, the escrow acknowledgement of it, and this is where you would initial that you presented the offer on the dates that you presented it. That's you. The agent does that. So that's it. We got all the way through. I'm not going to go into the buyer investigation advisory. It's just a list of what the buyer's investigations the buyers can do, and it's not even all of them. So we're not going to go into that. We're just going to finish off with the RPA part for now. Excuse me. Excuse me. Sorry. Choked. Any questions? Anybody have any questions? Okay, Melissa, let me see if I can find you on here so I can unmute you. There you are. Okay, go ahead.
Thank you, Kyle. For the last thing that you were saying about the presentation of offers, I feel like we've said, I feel like I've heard this before, that you always are obligated to present an offer to your seller, even if you're in escrow. Yes. So there's the distinction between present and reply, right? So you have to present it and initial where you presented, but they're not obligated to say, I'm accepting or rejecting.
Well, right? What they're saying about response to the offer is really more about counteroffers. Like, I don't have to engage with you on counteroffers. I can reject it on whole. I don't have to negotiate with you is what basically what they're saying on respond. Okay. Because we know that right now, as of now, until rules change, we're required to show proof of presentation if it's requested in writing, and that's the way we have to look at it. Okay. If nobody asks you in writing, you don't have to do it. I mean, you should. I just think you should. I look at it as, let's be as professional as possible. So yes, you should be doing that on the offers that you get that you're not going to accept. Just initial those portions. It's not hard.
Yeah, and that's what we send to the rejected offers email, right?
Yes. Well, no, the whole offer. Send the whole offer. Yes. You guys, great. I'm glad you brought this up. For those of you that work at Century 21 All Stars, you guys are supposed to keep rejected offers. The rejected offers you submit, the rejected offers you receive on your listings. You're supposed to keep those. I know most people don't. We have a place to keep those. So there is an email that you can send your rejected offers to that is rejectedoffers@c21allstars.com. That is for those of you guys that work here. And then we hold on to all of those rejected offers so you guys aren't required to do that. Just make sure that your subject line is the address of the offer. But for those of you guys that are watching this on YouTube later that don't work for our company, you've got to keep for a year your rejected offers. So you got to keep those. So whether your office does that or you do that, somebody needs to do that for you in your business. Yes, Jesus, let me get to you. Go ahead.
Yes, Kyle. So we have to submit our rejected offers to the rejected offer website. Now, do they have to be signed or initialed by our sellers?
I mean, they should, so that you have, so if ever it comes back that, hey, I don't think they presented my offer, you have the proof that they did. But it's not signed, it's just initialed that it was rejected. You should. Just having the rejected offer, as long as you did present the offer, is enough. But yeah, you should have that. All right, guys, anything else? Any other questions? Okay, next week we are going to go through the buyer representation agreement, the buyer representation and broker compensation agreement as it exists today. We're going to go through that next week. The SPBB, which is the seller's payment of buyer broker compensation, right? We're going to go through those two things. We'll talk a little bit about, maybe how we should approach those conversations with our buyers starting now, so that you guys are already in practice before changes come in July. So we'll be working on that next Thursday. Yeah, Danny, before we go ahead. Let me unmute you. Danny, you had your hand up.
I'm sorry, Kyle. So did you say that we have to send the selling agent the whole purchase agreement, or just that one page?
No.
Where the seller's rejecting?
No. Back to for the rejection, just those the pages that show that page 16 with the presentation But when you keep it, we need the whole thing. Like when you submit it to us, we need the whole thing. If we're gonna be the storage for you guys, we need the whole thing. If you're gonna store it, you need to keep the whole thing for a year.
Got it. Okay.
Okay.
All right. Thank you.
You're welcome. All right, guys. So I think that'll do it for today. I really appreciate you guys hanging in there with me for 7 weeks that we went through this thing. But we did a good job and we went through it. And now I think you guys understand it a little bit better. And I'm happy about that. So again, next week, we're going to cover the buyer representation and broker compensation and the SPBB. So if you're watching this on YouTube, right, you can see that video next week. It'll be uploaded. And if you missed anything, you can find this one on YouTube. And Jesus won't let me leave. So go ahead.
Thank you. And also, Melissa has a question really quick. So it is legal for us to save the other offers just in our email for a year? Because you mentioned we have to put them on the rejected offers.
Well, that's for us. If you send it to rejected offers, we keep it. We have it. I mean, we used to have a box where you guys could just drop the paper offers, but since most people are paperless now, we just have that email. So it's just a storage place for you guys.
Or
you
we
could
can
store
save
it wherever
for
you
1
want.
year.
Yeah, you could save it wherever you want. That's up to you.
Thank you.
I'm just giving you guys, we'll take some of that off your shoulders if you guys are willing to email it to us.
Thank you.
Okay, so Melissa had a question. Look at Jesus, what a gentleman. Go ahead, Melissa.
Thanks, guys. Kyle, I wanted to ask if on your YouTube channel, can you make a playlist specific for the RPA? Because I think
well, there's a playlist for contracts, IRONCLAD, so all of the contract classes are in there, and they should be in order. There is a playlist for that.
It's very accessible, though, if they're all into one little RPA one. It'd be very nice.
Thank you. Okay, I'll consider that. Thank you, Melissa.
Thank you, Kyle.
All right, guys. So that's it. See you next week. Check YouTube. Please, guys, share my videos and have everybody subscribe and watch the videos. I really appreciate that you guys are supporting me. So have a great day today. I will talk to you guys again soon.